Right. Good morning, everyone, and welcome to episode 126 of the On Air Advocate. We're at the On Air Advocate. We look to provide education, support, and empowerment for all of those with different abilities, mental and medical illnesses, and their caregivers. For those of you who may not know me, my name is Tammy Flynn, and I am the host and producer of the On Air Advocate. And I am super excited if you are joining us here on this Wednesday morning, or if you are catching this on the replay. Now, as always, if you think that the content we're talking about today could be relevant or helpful for anyone, if you could please hit the share button and share the love with others. Well, if you guys have been following us this last week, we have kicked off our support and education series. And I am so excited to welcome today to be here with us, Attorney Davis. There is so many areas when we talk about support and education and knowledge for families that comes from the legal perspective. So I'm so excited to have you here this morning.
Thanks. I'm so excited to be here.
And I know that we're going to kind of dive into the whole guardianship end of things as kiddos are aging out of school and going into their adult years. But Attorney Davis, I would love you to just give us a little bit about your background and kind of what led you into this field.
Sure, absolutely. So I graduated from Marquette Law School in 2011. So pretty soon, in a couple days here, I'll be 8 years out of school. And the whole time I focused on disability law. I have a younger brother who's 5 years younger than me who has spina bifida. And he is... He's a success story. He's working. He graduated from WCTC. He graduated high school, not without a lot of difficulties, but every step of the way there's been new challenges. And I'm sure a lot of the listeners can relate that every stage of life there are always new surprises and things to work through. So that's what led me to want to focus on disability law. So my practice now, my partner Rod Pladel and I focus on pretty much all areas of the law that touch disability. So from special education, guardianship and decision making, estate planning, we help families of kids with really high needs get county funded services. We do adult services, appeals issues, neglect and abuse, and then regular issues like criminal and family law. When you have a disability, they can look a lot different. So we handle all those types of issues, and then also some federal civil rights, Americans with Disabilities Act, and discrimination and those type of issues as well.
And I think that, what I'm always passing on to parents is knowledge is power. And so really to move forward in the space of different abilities, and as our kids become young adults and whatnot, and they take over some of that ownership as well themselves, really having that knowledge of where your rights are is always number one,
Absolutely. Absolutely, and you don't know what you don't know. So sometimes you might not realize that something's going wrong, or it's not as complete as it could be if you don't understand your rights.
Yes, and I know, Attorney Davis, we talked before the show that we definitely in the future are gonna, possibly dive into some other topics, because there are so many topics when it comes to our different abilities, community, and all the different things you were just listing. And that even comes down to as simplistically as the regular individual educational process, the IEPs, like through our school systems and all of that. So there's so many different areas of this, but I know today we are really gonna zone and focus in on guardianship and those alternatives. And for the audience that's watching, sometimes people don't even understand when we are referring to guardianship, getting guardianship, what is that? Could we just kind of start with a definition of why someone would be seeking guardianship, and where is it appropriate, and then kind of going into the stages of how to go about doing that?
Sure, absolutely. So anybody right now who has a minor child, so a child under 18, you are the legal guardian of your child. The guardian is the decision maker. So when we're talking about minor children, that's all the major decisions that you're making as parents on a daily basis. When children turn 18, a lot of parents, especially of kids with significant disabilities, assume that it will continue to be business as usual. But at least in Wisconsin, where I practice, once they hit that 18th birthday, if there's no other legal mechanism in place, they're their own person. That means they are able to make their own decisions, or at least no one else is able to make decisions on their behalf without, again, having that formal guardianship or other mechanism in place. So for an adult, and in Wisconsin, guardianship in terms of the guardian's responsibility means the authority to make major decisions about healthcare, education, social services, where you live, where you travel, and then a whole lot of other responsibilities. And there's kind of a catch-all that says care and custody of the individual. So it's allowing, when we're talking about being the guardian of your child who is aging out into the adult system, it's allowing you to basically continue your parental responsibilities in a lot of the ways you have before they were 18, after they become an adult.
Right. And I know that, and we can kind of take this kind of chunk by chunk in our open conversation. There's a lot of talk about when is the time to do that. And now I was always urged, and obviously I've went through the guardianship process with my son, is that I was urged to, in Wisconsin, to do it at 17 years, 9 months, where you could be in, court at that time, or start the process. Is it starting the process, or is it being in court?
You can have your hearing at 17 and 9 months.
Yeah,
that's the earliest you can have it.
Right. Now, in some other states, like we talked about, that might fluctuate a little bit, but it's going to be right in that same ballpark.
Yes. It's going to be right around age 18. In Wisconsin, you can file your guardianship paperwork at the courthouse when your child is 17 and a half. And the reason it's 17 and a half is because from the day you file your paperwork, the court has 90 days to decide your case, or 3 months. So that takes you to 17 and 9 months, which is the earliest possible day that the guardianship can be entered.
Right. And then if you have that, then obviously everything will be in place for you then when your young adult turns 18.
Yes, absolutely. So to the extent that it's possible, I would highly recommend having your hearing, if you're going the guardianship route, be before the 18th birthday, because there's so many other things that happen at age 18. It's good to have that in place already.
Right, because moving forward, which that would be a whole nother topic, at that age 18, if you're going for SSI and Social Security and all of that, and having all that in place and filling out the paperwork and being the signer of all that, it's good to have all those things in place before that next phase.
Absolutely. Absolutely.
Now, years ago, I was told by Mom, now this is before my son was even 18, they were talking about, she had 2 older kids that she had waited, and it was pretty difficult, that she waited till after they were 18. And, then it kind of looks to the court as if, like, if you wait till they're 20, well, why didn't you do it at 18? If they really need full guardianship and they really need, your signature and your authorization for the things that they're doing for their health and well-being, why would you wait till they're like 20? Do you see there being complications aside from that other paperwork, if someone does not get it done right away?
Sure. So there's a couple kinds of complications that we see. So I'll answer your scenario first. We see families all the time that make it work without guardianship by doing all kinds of different informal things, some of which we'll probably talk about today, like supported decision making in an informal way. But then something comes up where either a medical provider isn't, accepting their whatever they've been doing before. They feel that the person needs a guardianship, or, well, let me circle back to some of those problems that come up later. If somebody makes it to 20 or 30 or even older, and they haven't had a guardianship now for 5, 10, 15 years. And they, especially if they don't want a guardianship, if they're not agreeing that they need help or they need that level of help, you could run into a major issue proving to the court that it's necessary when clearly you've been able to make it work for this amount of time. Now, there are plenty of situations where you would be able to show as a parent, well, the way we've been making this work is basically having the structure in place that looks a lot similar to guardianship. So I see people often kind of between 18 and 21 going into court. And I wouldn't say it's a huge problem, but like I said, if that young person isn't on board with the guardianship, it could be. The other issue is that I see with not having it done close to the 18th birthday is you get these gaps. So when the child is 18, like I said, they can make their own decisions. They can sign themselves out of school. They can quit school entirely. They can say, I don't want mom and dad at the IEP meeting, and big decisions can get made that, probably might not be in their best interest. They can get into financial trouble. And then the worst, the nightmare scenario, which I don't say to scare people, but is you run up against, they need medical care, and whoever the provider is says, I am not going to accept their consent without some kind of proof of guardianship. So all of those things kind of together are reasons that if guardianship is the way that you think is best for your child to go, the closer you can get it, either before or immediately after the 18th birthday, the better.
Okay. Now, I know that it's not for every state, right? The whole supported decision making, but I do know, because I listed on our on-air advocate community right when that happened. Isn't there like 9 or 10 active states, or do you have those states that have that in place already for supportive decision making?
I guess I'm not sure exactly which states have it like formally into law. I know that last year when our law passed, we were only the 3rd state to enact formal supported decision making into law. What are
the other 2 states that you're aware of?
I'm actually not sure where else already has it.
Okay, I'll dig up that information. I had posted it because I believe I think there's a total of, I thought there was like 9. And then there were some that were kind of in that process, but like you said, they probably weren't fully enacted. Like they were in the process of starting it.
Sure.
And I can drop those below this live so that, people know what states that, there's a supported decision making. So can you explain to the audience what is even the supported decision?
Sure, absolutely. So supported decision making as a concept has existed for a really long time, and in that regard, in any state, you can do informal supported decision making. So examples of that are ways that any adult could help any other adult make big decisions. So you can execute release authorizations saying, I want Tammy to be able to talk to my doctor. I want her to be able to come to my IEPs and look at my records. I want her to be able to communicate with my bank. Anybody can execute those at any time. They're usually specific to the provider. You can do things financially, like set up a joint checking account or a dual signature checking to help manage money. You can, for a lot of settings, like for example, finding an apartment, finding a place to live, you can bring somebody along with you whenever you want, and it doesn't have any formal legal relationship. So those ideas, having just person to person, helping each other out, making decisions of supported decision making have been around for a long time. But for people with disabilities, this can be a really huge deal because it allows you to maintain self-direction and control over your own life while getting the help you need when you need it from the people you want to get it from. And I've been telling people we all use supported decision making every day. In fact, I would argue that this interview that you guys are listening to right now is an example of getting input from other people that you trust, obviously Tammy, on things that are important to you. So we all use it. The supported decision-making agreements in Wisconsin, which follow the other states' models, allow a person to designate a supporter. That's the name of it. So rather than a guardian or an agent, it's a supporter. And they can help you make decisions about some major categories, including obtaining food, clothing, and shelter, making physical and mental health care decisions, making financial decisions, education decisions, and work decisions. So those are kind of the categories that it's broken down into. But the supporter cannot act on that person's behalf. You're acting together, and the ultimate decision comes from the person with the disability. They are the decision maker. So if I say I want Tammy to be my supporter for healthcare, you can look at my records if I give you permission to do that, but you still have to have a release authorization, and you can't go in there without me and get my records and take a look at them and then tell my doctor, okay, this is the treatment plan that we're going to do for Vicki. It's a much more collaborative process. The other thing about it is that the supporter, the person with the disability does not need to do everything with the supporter. So they can still keep doing things on their own, and they can choose, I need help at this meeting. I'm going to name my parents as supporters for my IEP meetings. I want to make my own decisions at those. They're there, they're helping. You guys can share my records with them, but at the end of the day, the buck stops with me. I am the decision maker. Does that kind of make sense?
Yes, but now would that be in conjunction with going for different levels of guardianship? So is that an actual legal process that you go through that it kind of gets added and kind of morphed into that guardianship? Or is it completely a separate thing? Like you don't go for guardianship, you go for supported decision making, and you make up some legalities around that?
So both things you just said are options. So supported decision making, it can be done completely by itself. You can go online and print off a supported decision making agreement, just like you can go online and print off a power of attorney or a well, either for healthcare or finances, and follow the instructions and do it. You don't need an attorney to set up a supported decision-making agreement. So it is a legal document, but there's no court oversight at all. And then it can be used in conjunction with other decision-making vehicles. So you could have it with a power of attorney. You could have it with a limited guardianship. If you had full guardianship, it would be somewhat difficult because the guardianship controls. So if the guardianship transfers decision-making authority for all those things I just listed, healthcare, finance, finances, education, social services, all those things, there's not a whole lot left that a supported decision-making agreement would cover that the guardianship wouldn't overrule or trump. Okay. But if you had a limited guardianship where the court let the person retain some of their rights, they actually complement each other really well.
Okay, now a question that I'm asked quite a bit, and I only can reference back to the reason why I decided to utilize having an attorney when we went through the guardianship process, which actually me and Attorney Davis got to meet each other years ago through that process. What would be the reasons when someone's coming to you to say, you know what, we are looking at guardianship, we're looking at supported decision making, we have all these things. Why would we decide to hire an attorney versus doing it on our own? That's always a question. Like, do I need an attorney? Do I need one? And if I did, why would I want one versus not?
Sure, absolutely. So attorneys are issue spotters. So you have one idea or probably several, but you have an idea of your family and what your needs are. But you might not have considered, if you think that like a bike wheel with all the spokes, all the other issues that are coming off of surrounding your young person. So maybe your plan was to go with guardianship, but you didn't realize, for example, guardianship oftentimes takes away the right to vote. It can take away hunting and fishing rights, the right to get married, things like that. And I think people sometimes don't realize how restrictive it is. So, just having somebody there to help you explore what the other options are and then how they interplay with everything else. But in terms of guardianship itself, it is possible to do a guardianship without an attorney. On your own, to file paperwork on your own. But I would definitely recommend that people consult with an attorney. So I know, for example, in Wisconsin, there are free legal clinics where you can get help having the initial paperwork filled out totally for free. One of those is run through Marquette University Law School, and they have if you Google MVLC, which is Marquette Volunteer Legal Clinic, it has all their locations and times and all of that. But I see attorneys who don't specialize in guardianship mess up guardianships all the time. So I will say you can do it, but do your research, and it's not easy to walk yourself through that process without an attorney. And I know you're probably thinking, well, of course you're going to say that, you're an attorney. So that's why I tell you, I see attorneys mess it up all the time.
And to speak to that, when I was interviewing and looking, because like we talked about at the beginning of this, all of this is about having, knowledge. And the only way you can do that is doing that investigation and being a good advocate. And I had called and talked to 6 different law firms.
Okay.
All of them gave me a different answer. And, obviously I ended up going with your firm, and a lot of that was backed by other people within our community in our state that I saw utilize you guys, and it, did an amazing job. And so, and mine had a few more layers to it. But I do, tell people that, especially if you have questions and things aren't answered when you're doing it yourself, like you're saying, you're kind of in uncharted territory, of not really knowing. And I remember that conversation that we had about the hunting and fishing. And for other people that live, on the East Coast or on the West Coast, it might not be as big of a thing. But I remember you talking to me about, living in the Midwest, hunting and fishing and all of those things are a huge part of our culture, here in the Midwest, of things that we do in the wintertime and whatnot. And I just remember you talking about that, in the fact that when you have full guardianship, you lose the right to do those things. And something I would have never even thought of. I mean, who would have thought that has anything to do with guardianship, going hunting and fishing, and so I just think that there's a lot of value to that, to investigate. Is there a central location that you know of, or possibly that you could find, that we could drop a link below, like where, or in every state, is there somewhere that's a great agency to kind of go to find out where people can seek out help? I know here, like our ADRC, I think that they can refer people out, our Department of Aging and Disability Resource Center.
Sure.
Do you know if that's the same in every state, or?
Sure. So every state is going to have what's called a protection and advocacy agency. So in Wisconsin, it's Disability Rights Wisconsin. In other states, they have different names depending on the state. And every state will have one. So that's a good place to go for guardianship resources. Usually Medicaid services, so you mentioned the ADRC, the Aging and Disability Resource Centers, are connected to the county. So if you contact your county Department of either Human Services or Health and Human Services, depending how it's named, they can be a great resource. There are some organizations, for example, the ARC, does have branches in many different states. They have great resources. And I think right now in Wisconsin, between the ARC and the Board for People with Developmental Disabilities, those are probably two of the best resources online for all the whole range of options from supported decision making on up. And then also here we have GWAR, which is the Greater Wisconsin Aging, I forget the second A, but it's GWAAR, and the R is for resources. They have a ton of information on guardianship. All of our forms that you need to do a guardianship are available through wicourts.gov, and then you click through to forms, and then you click guardianship, and everything you would need if you were going to do it yourself, or if you just want to see what's involved, everything is available there. And most states are going to have all of their state court forms available online as well. And you can check your the law schools in your state have usually pretty well organized links to information about certain areas of law. So in some states, I know they call guardianship conservatorship, for example. So you might have to look it up under that name.
Okay. Now, something that we didn't touch on, two different things that are on the top of my head. The first is that as they're going through the guardianship process, obviously you're kind of walking uncharted territory, having an attorney, but looking that, you know, I don't know, when we talk about families with individuals and them different abilities, I think the divorce rate for parents is, you know, so divorce rate is high to begin with. It's even higher in that case. So what are issues that sometimes you see going into guardianship when, you know, there are two families and, you know, they're divorced and whatnot? Can that become kind of a sticky situation?
Oh, absolutely. So one thing, well, I'll talk about divorce first. So in Wisconsin, in the courts where I practice, courts are getting more and more reluctant to name co-guardians in general. So I have had a couple petitions come through recently where the parents were married and they were listed as primary and secondary. So I was guardian ad litem on those cases, which is the attorney who advocates for the young person's best interest. And I said, no, you've got married parents here. They need to keep doing what they've been doing, and it did go through. They do not like to appoint co-guardians that are not married parents of the person who's under guardianship. So a lot of times in a situation where there are divorced parents, you can end up having a contested hearing, which is basically a trial about who should be the primary guardian, who's the primary decision maker. What a lot of families do is that one parent, often not always the one who was the primary custodian of the child while they were a minor, they become the primary guardian, and then the second parent is the standby guardian or the backup. That happens. That's probably the most common solution. However, if you can't hash it out and you end up, going into a court battle about it, the court might pick one parent or the other, or they might appoint somebody totally different. It could be another family member, but it also could be what's called a corporate guardian, which is basically an agency that serves as the decision maker for usually a bunch of different individuals.
Right. So that's some big stuff. So I always urge parents, I guess, that I meet along the way that if you have any of those complex situations, I mean, indeed, you really should seek out legal help and advice for that. Aside from the supported decision making, are there any other alternatives that can kind of be brought into guardianship? Is there anything we're missing, like when we're talking about choices for different things? Or those kind of the options that families have?
So there are a couple other options. So one thing for managing finances is that in Wisconsin, at least, to have a guardianship of the estate, you need to have an estate that's $50,000 or greater. Most 18-year-olds don't have $50,000. They don't have 50 cents half the time. So parents are able to become the representative payee. So that allows you, if your child is going to be eligible and receive SSI, that allows you to manage those funds without the need for guardianship. There's also a small estate exception that can allow you to manage small amounts of money if your child, for example, has a job where they're, earning, I think you can earn up to $1,100 some dollars a month right now with Social Security and still keep your benefits. So managing those amounts of money. The other big option is powers of attorney. So there's healthcare and financial powers of attorney. Those are, there's no court oversight with those. You can go online, print them off, the state of Wisconsin, and whatever state you're in, your state will have power of attorney forms that you can go online and print off, follow the instructions for how you execute them. They need to have witnesses, or you can get them notarized, one or the other. The healthcare power of attorney covers major healthcare decisions, and it also, at least in Wisconsin, addresses being able to admit you to a facility. Every adult, disability or not, should have powers of attorney for healthcare and financial, because disability is the only protected class that anybody can join at any time. You never know when you are going to need a substitute decision maker. And then healthcare powers of attorney also address, like, do you want a feeding tube to be used in the event that that would be necessary to continue your life? So it's a big decision. The financial, or also called a durable power of attorney, addresses all kinds of issues around finances, but you can also address things in there like nominating a guardian, handling your mail, some things outside of just regular financial decisions. The thing about those options is that in order to have them be valid, you have to have what's called the capacity to execute them. So you have to be competent enough to understand, what is this document? What are the powers that I'm giving up and giving to somebody else? What are they going to be able to do on my behalf? Who is somebody who makes sense to be able to do this for me? So sometimes parents who want to avoid guardianship say, we're not doing guardianship, we're going to do healthcare powers of attorney. The child executes it when they're 18, and healthcare powers of attorney have to be activated by 2 doctors, or 1 doctor and 1 psychologist. They sign it, and the next day they go take them and get it activated. So it's activated immediately, which means the doctors are saying on the next day they were not competent, correct? So that means if they weren't competent on Wednesday, probably weren't competent on Tuesday when they signed the paperwork, if that's, the way it happened. The other thing about healthcare powers of attorney versus either supported decision-making or guardianship is that it covers healthcare. It does not cover social services, education, all these other issues that we talked about earlier. So if you're going to go that route, it's good to make sure, especially for a young person, if they're going to be, well, I was going to say if they're going to be in school till 21, but even if they're going on any type of higher education, or into the workforce, to make sure you have something to cover those decisions as well.
Right. So the thing is that there are some of these alternatives and little things that you can do, but ultimately it's really best whether it is through one of your free state services or seeking out an attorney to at least, even if they're not going to do the whole process, kind of walk you through these different options, look at the layout of the land of your situation, and then decide moving forward which would be best for different areas.
Absolutely.
Because I know that even just listening to this conversation, I'm like, there's a lot of options and there's a lot of things to think about.
Oh, sure.
Yeah. So it's a whole lot more than that you can go on, print off some paperwork and fill it out and submit it into the court.
Sure, absolutely.
You know, a lot more that way. Would there be any other, in kind of our wrap up, would there be any other advice that you would give to families, or that you kind of like to, you know, leave everyone with when it comes to this whole entire process?
Sure, absolutely. So one thing that happens a lot of times at 18 or around 18 is that you're not just aging out of school in the children's system, you're aging out of pediatric care into adult care. So you're changing your child's whole team. A doctor for guardianship, you need a doctor's evaluation or a psychologist's evaluation showing what level of guardianship they need, and, you know, making an assessment individually to each of these rights. Your child's doctor, whether it's their general practitioner or a specialist they've been working at, they're going to know them best. When doctors who come in who are, you know, take court appointments, they meet your child, they've maybe spent 30 to 45 minutes with them. Their answers, I think, tend to be more protective. So where your child's psychiatrist or psychologist that they've seen since they were 5 might say, of course he can vote. Of course he understands the concept of, I'm choosing between a couple options and this is the one that I want. Somebody who doesn't know him or her and spends that short amount of time might not come to the same conclusions. So part of the reason to start early is to make sure that the person filling out this report that will affect your child for the rest of their life, if it's a permanent guardianship, knows them well enough to really answer the questions thoroughly. So any reports within a year are considered current enough. So around the time your child is 17, start talking to the doctors about decision making. And maybe the doctor says, look, I think powers of attorney are fine. I think supported decision making is the way to go. I don't think you need guardianship. But start having that conversation. And also, anybody whose child has an IEP, starting at 14, once you hit those transition years, what decision-making is going to look like as an adult should at least be part of a conversation. So long story short, it's never too early to start thinking about this. Another thing is that courts are supposed to consider whether there are less restrictive options available for a child. And I'm saying child meaning your child, not a actual minor child. So could we provide some education, training, and support to this young person that would get rid of the need for guardianship? Quite frankly, I don't think they spend a whole lot of time considering it. But if this is looking at your transition process in your IEP, if you're seeing gaps in your child's ability to function as an adult, start working on training on those things. You know, how can we work on your money management skills? How can we help you learn how to advocate for yourself at the doctor's office? And maybe they won't be able to make those decisions independently, but at least you can say we have done what we could to help them have the most self-direction that they're capable of. An informed decision doesn't mean a perfect decision, and it doesn't mean that you make the right choice every time. All of us didn't make perfect decisions when we were 18 or right now. So also just remembering that your child with a disability is not different than your other 18-year-old kids that you've had yourself or other kids that you know, and they have growing pains with learning and making decisions too. So sometimes people panic and our instinct is to protect our kids, but you want to make sure that you're giving them, you know, again, the most ability to self-direct that is appropriate for them and that you can.
Right. Well, that was a whole lot, but it's so needed to be said. And I want to reiterate what you were talking about starting early with this process.
Yes.
That it is never too early. And especially, my son is going to be 22 this year, and the whole aging out of process and even leaving school, between 18 and 21, and all of your services change and developing a new medical team. It has been like the day he was born all over again, like starting all over again, because it's all brand new territory. And when we talk about guardianship and we talk about, looking at the options that they have for self-direction and all that, those are all new things. We haven't been working on them for the last 18 years. We've had an IEP very directed in our behalf, teams coming together, talking to us,
Right.
where this is a lot of, so where do you think it is? What do you know what I'm saying? It's a lot of really evaluating, and how much growth do you think can happen? And is there going to be growth? And it's like you're talking about the rest of your life.
Yeah. Yeah. And I mean, I think the IEP is one of the best examples. You look at IEP goals and it's like, you're going to read this many words in this amount of time. They're very specific.
Yeah.
You get out of high school and all that falls away. And you're kind of like, where am I? Who's telling me, what the options are? And so I think that making a plan for decision making is such a huge part of the transition plan. But sometimes it's kind of like, oh yeah, and here's a flyer about guardianship, bye. So.
Yeah, and there's so many layers. At our support group meeting that we have here in our county, I had a mom that I was chatting with, and we were talking about, the different layers. And sometimes we think guardianship and SSI and IRIS and community funding and all of that are all lumped into one document, but they're all completely separate things you have to apply for.
Yes.
And so you're going to have 5-10 new brochures of things you're going to have to tackle. So I thank you so much, Attorney Davis, for spending this morning with us. Your information is so valuable to our audience and our network, and I just thank you for the population that you serve and helping all of us.
Well, thank you so much for having me. And if anybody has questions, our Facebook and our website, they're both Davis and Plato. So my email is on there. So feel free to even email me or call or shoot me a Facebook message, and I'd be happy to talk more with you.
Yes, and underneath this live, or after we get off the show, if I can we can grab all of those names, kind of drop them below, like some of the services that we were talking about, some of the county agencies, also your information. We're going to drop that right below, like where your website and all of that, so that they have easy access.
Okay, sure. I'll get that to you. I have all those resources. The links, and I'll get you the other states that have supported decision-making agreements enacted into law as well.
Okay, that is awesome. Wonderful. Well, hope, Attorney Davis, to have you back on again so we can talk about some other topics. I thank you for spending the time with us again this morning. If you guys want to learn about any of the other services the On Air Advocate has to offer, you can head right on over to onairadvocate.com and you'll find them all right there. Or if you would like to become a part of our private On Air Advocate community, you can head right up to the top of this Facebook page, hit the blue button, and that will let you into our private group. So on that note, I hope you all have a fabulous Wednesday. Thank you so much again. Bye-bye. Thanks for spending the morning with us.
Bye. Thank you.